morning. This is Attorney Vince Davis, and these are live morning hours on Facebook. Today's question, someone asked me, hey, Mr. Davis, can you explain what happens at the court hearing? And in their case, they were talking about the jurisdictional court hearing. It was the second or third court hearing in the juvenile dependency module. So let's talk about what happens at the jurisdictional hearing. Usually, I'm going to start right at the beginning. You appear in front of a referee, commissioner, some sort of temporary judge, or a full judge. And in an earlier video or office hour, I talked about, how you can ensure that you have your case heard by the type of judge that you want. And there are things that you can do to change judges. I mentioned there is the CCP, California Code of Civil Procedure, section 170.6, that you can file to change judges. Now, generally, a lot of this stuff happens that I'm going to mention now to you at the detention hearing. But in many cases, the parent didn't get appropriate notice of the detention hearing, and sometimes they show up for the first time at the jurisdictional hearing. Now, the court must inquire about the child's parentage. For example, a lot of people assume this is just a waste of time or irrelevant, but it has important repercussions throughout the case. So generally, we establish who the mother is. The next thing that we want to do is we want to determine who the father is. And in California, there are several different types of fathers. The presumed father is the father that is recognized by the court and who is given substantial rights, including family reunification services. So, maybe I'll do a video in the next week or so about the different types of fathers there are in California. I think we're up to maybe about 5 or 6 different types of fathers that can be recognized in the juvenile court. A lot of people think the father is the biological, father of the child. We call it the bio dad. Well, that's not necessarily true in juvenile dependency proceedings. Next, the court has to inquire whether there is any American Indian ancestry. And remember, I say most courts, especially in California and the counties that I go to, make this inquiry of American Indian ancestry right at the detention hearing. But as I said, sometimes the parent doesn't attend that detention hearing, so the court has to make this inquiry at the jurisdictional hearing. Now, what difference does it make if the child has American Indian ancestry? It makes a lot of difference on how the case is going to be handled now and in the future if there is American Indian ancestry. There are special federal laws that apply, the Indian Child Welfare Act, and those laws control and give, in my opinion, Indian parents or Indian children more protection than what's given under California law, under the Welfare and Institutions Code. The court has to check also the names and dates and addresses of the parties so that notices can be given. And then the court has to inform the parties that they have the right to an attorney. Now, the right to an attorney is extremely important in California cases. If you aren't able to afford an attorney, most counties, and I would risk to say even all counties in California, will appoint you an attorney to represent you, or you can hire your own attorney. Now, I had an interesting conversation with someone yesterday, and the person was making complaints about their court-appointed attorney, and I said, look, I don't make any comments one way or the other about court-appointed attorneys. 15 years ago, I was a court-appointed attorney. but they were complaining about their court-appointed attorney and saying this and saying that. And I told the woman that, when you're appointed an attorney under California law, there's a case, and it doesn't use these words, but basically, you're not entitled to have Johnny Cochran represent you in your juvenile dependency case. You basically have someone that will do the basic minimum job. We were talking about things that the client could do in her case, and she had seen the video on pretrial motions. And she asked me, well, why doesn't my court-appointed attorney look into all of those pretrial motions? And I said, first of all, pretrial motions are very rare in real practice. There are a lot of procedural, substantive, and strategic things that an attorney may or may not want to do. And I said, in my humble opinion, under California law, a court-appointed attorney, in those cases, doesn't necessarily have to make those types of motions. They can choose to handle it later or in a different fashion. So, you're entitled to an attorney, but you're not entitled to Johnny Cochran. I'm just saying, I'm just the messenger. That's not a personal opinion of mine. It's just what the courts in California say. Um, Also at this hearing, if it hasn't already been done, the court will ask each parent to confirm, his or her mailing address. The mailing address becomes important because later on in the case, certain types of notices have to go out. But there's something that doesn't come up usually in juvenile dependency cases, and that is that under, I think it's Welfare and Institutions Code